Okay, you're live.
Hello, everyone. Good afternoon. My name is Rosario Ubiera Minaya, and I'm the Executive Director for Amplify Latinx. I'm welcoming you to another webinar from our series for business resiliency that we have launched as a virtual series to support the needs of small businesses as we go through this crisis with the pandemic. I'm excited about welcoming our two panelists today, and in a few minutes, I'm going to introduce them. But before we do that, I want to go over some information, just logistical information that I want to make sure that we all are on the same page about how to manage Zoom. At this point, I think we've all been kind of like exposed to the virtual platforms and all been using Zoom here and there. But I just want to make sure that we understand that we have controls, that we can ask questions through the chat. At the same time, that if you have a question, you can raise your hand and I can see that and let you in. But this is going to be very informal, and our presenter today will take questions as we go through the presentation. Also, I want to tell you that this session is being recorded, and we're going to make it available after the session through our thank you email that we'll send you with information about the session, with the recording, as well as some resources that we're going to share with you, and also a survey. This is a very short survey that we would love for you guys to take a few minutes and complete. It will give us feedback about these sessions, and also we're going to ask you about any other topics that you want to hear more about and learn more about, and we're happy to incorporate them as we continue with these virtual conversations. So with that said, I also wanted to let you know that we have more things coming, of course. So we launched this business resiliency series, but at the same time, we also launched our Cafecitos programming through a virtual platform as well. And the next one that is coming up is on May 5th. We just completed one this morning with Representative Santiago. And these are just, again, opportunities to interact, create community, share resources, ask questions, and stay involved in all this kind of rapid changing situation that we are all facing. So the next one is on May 5th with Clara Diaz, and she's gonna talk about the lean model. Now I'm excited to introduce William Lane, and he is our presenter today, and he's gonna talk about, well, you're gonna let us know what you're gonna be talking about, but you are a state administrator, and you are part of the Lawyers for Civil Rights group, as well as Priya Lane, that is also joining us. And Priya has been also a great supporter of the work that we've been doing with Amplify, trying to educate our small business owners as we continue going through this process. William is gonna go over most of the information today, but Priya is also available to answer any questions that you may have. But with that said, thank you so much for joining us this afternoon. And William, you can now share your screen. So you can, so we can see your slides. Also, if you can introduce yourself and give more information about what you are presenting today, that will be great. Thank you so much.
Absolutely. Let me start my slideshow. So my name is, I said, Will Lane. I'm an estate administrator at Goulston & Stores in firm in Boston, and I am Priya Lane's husband. Yes, maybe you can see from the video, she gets the nice kitchen. I'm down in the basement.
I know that. If I have known that, I will have, of course, that was going to be part of the
yeah.
That's why I said I just saw him when you asked me when he was coming in. Well, let me, just before you start, Will, I just want to talk a little bit about LCR, if that's okay. So I'm the BizGrow director at Lawyers for Civil Rights, so we help minority, immigrant, and women-owned small businesses through the life of their business. And we are here to help you guys with any sort of business needs you might have. Will is my husband, and he works at Goulston & Stores, and so he knows a lot about business succession planning and estate administration. So which can be really helpful for small businesses. But if you have any other business questions or anything else you need help with, I'm always here, and I'm going to be here today to answer any other questions you might have.
That's right. So today I'm going to be going through some business succession planning. We'll start out with sort of some general estate planning overview, because that's really, what we're going to need to know before we think about business succession and passing the business on to, your children, your family, passing your business on to a business partner while you're still alive, passing it on to your favorite employee and retiring while still earning some income from it. But all of that, how does it fit into your estate plan overall? And what is an estate plan? What does that mean? That's what we're going to get started with. So the estate plan is essentially the documents that will manage your assets should you pass away or should you become incapacitated or lose the ability to manage your assets or your business for yourself. And at the core of these documents, the core of the estate plan is these four documents. So you have a last will and testament. There's the will. I'll refer to it as that throughout the presentation. You have a revocable or an irrevocable trust. You don't have to have a trust. It's a good option. I'll go over the differences between those two types of trusts, go over what a trust is in the first place, as well as why you may want to have one. And I'll also talk about a healthcare proxy and a durable power of attorney. Those are sort of the core documents that make up a good estate plan. And you don't, you may have a trust, you may not, but you'll certainly want to have a will, healthcare proxy, and power of attorney in place. So the will is sort of the most popular one. It features quite a bit in popular culture, movies, and TV shows. It basically controls what happens to your stuff when you die. You can say, I give, this to this person, I give, that to this person, or you can say, I give it all to my spouse, or I give it all to my children equally. It also appoints your personal representative, which is the person who's in charge of managing your estate. In 2012, they changed that from the word executor. So if you're an executor, personal representative, they're the same thing, but now the law refers to them as a personal representative. And this third point here is it only controls property in your own name with no designated beneficiaries when you die. And that's a key point. So if you have life insurance, for example, and you've named your spouse as the beneficiary, your will has nothing to do with that life insurance. That life insurance benefit will pass to your spouse when you pass away, and your will doesn't have to get involved. If you have a retirement account and you name your two children as 50-50 beneficiaries, again, the will doesn't get involved. That retirement account is going to go to those two individuals 50-50, and the will doesn't have anything to say about it. It's only when we get property that doesn't know where to go when you pass away. So it might be a bank account that you have in your own name with no beneficiaries set up or no transfer on death designation set up. And so the bank account doesn't know where to go. It's got nowhere to go, so we're going to have to look to the will to say where that stuff goes. Now, a will is just some words on some paper until it goes through the probate process, and I'll go over that briefly as well. But it has to go through the probate process, the court process, to say this is officially this person's will. And the personal representative has to be appointed by the probate court as well before they have authority to act. So you can't just take your spouse's will and say, look, you see here it names me personal representative, give me the bank account. That's not going to work. You need the documents from the court. So probate is there's probate court, and probate comes from the Latin word probare, which means to prove. When I learned that, it really sort of helped it click for me. So I hope it helps you too. And basically what we're doing is we're taking the will and the death certificate and some other probate court documents to the court and saying, we're here to prove that this person is A, deceased, B, this is this person's last will, or we're going to prove that you didn't have a will. And we're going to also prove who should get the property. And that's either the people who were named in the will, or if the that person doesn't have a will, it'll be their heirs. That's who would receive the property under state law if you don't have a will. I'll go over a quick overview on who your heirs may be. If you have a spouse, then in all likelihood your spouse is your sole heir. And if you pass away without a will, all your stuff would go to them. If you don't have a spouse, but you have parents and no children, then all of your assets would pass to your parents. Similarly, if you have no parents, you have siblings, they'll go to your siblings. But most common cases, if you have a spouse, it'll go to your spouse. If your spouse passed away first and you have children, then your children will be your heirs and your stuff will pass automatically to them. And that's if you don't have a will. Your will can change that. It can stick with that plan if it wants to. But that's who your heirs are. And then we're also going to prove to the probate court who the decedent wanted to be the personal representative. Who do they want to be in charge of this probate process? And once you file these documents with the probate court, it takes anywhere from 2 to 4 months, depending on what county you're in, to get the personal representative appointed, and the administration can then begin. So it's a pretty slow process. Suffolk County, for example, which is where I do most of my work, at this point they're taking closer to 4 to 6 months to get a personal representative appointed. They are pretty backed up, and they also had to close for a few weeks to do a deep clean because someone there tested positive for coronavirus. So they are slow there at the moment. And then once that gets started, it takes at least a year, a little over 1 year, to wrap everything up. And this has to do with how long people who have a claim against the estate can file their claims. So if you have a credit card, for example, you owe $3,000 on your credit card when you pass away, that credit card company has 1 year to file their claim for that $3,000 with the court. So we lawyers were conservative, so we like to say we're not going to file, we're not going to close the estate and distribute everything until we know that no more creditors are going to file claims, and that's why it takes a little over a year. And it's not cheap. The probate process, the filing fees alone are $400 to start a probate. And then if you're going to be working with an attorney, it can basically be anywhere from $3,000 to $7,500 would sort of be my estimate. It can, of course, it could vary depending on the complexity, the people involved, whether there's conflict in the family, but that's a general cost frame. But what is a trust? That's another key document that we talked about for estate plan. So it's when one person transfers property to another person with instructions that that property be used for the benefit of someone else. So we're going to break that down here on the next slide. There's 5 ingredients in that definition that I just gave. The first is a grantor. That's when one person transfers property, stuff, assets, a bank account, some real estate, whatever it is, to another person. That person is the trustee. They're in charge of the trust, and they give them instructions. So the grantor is giving the trustee instructions on what to do with the property, and it's for the benefit of somebody else. So it's going to be, invest this cash and give the income to my children, or use it to pay for their school. Really, you can almost set up a trust for anything, or you can just say, when I pass away, give the money to my children. An example of a trust that occurred to me a couple of years ago was I was over at Priya's parents' house, and we were having pie and ice cream, it's a popular dessert over there at their house. And so I was slicing the pie, putting it in bowls, adding some ice cream, and in the kitchen. And then my niece was taking this pie and handing it out to everybody in the living room, and then of course they were then eating it. And I realized that that's basically what a trust is. So I'm the one person, I'm the grantor, I'm taking the pie, which is the property, and I'm giving it to another person, and that was my niece. and she was in charge of the pie, and I gave her instructions. I'd say, take this piece to your grandpa. And she'd go into the kitchen, or out of the kitchen, and give that pie to her grandfather, the benefit of somebody else. He was the somebody else. And, you know, it's pretty simple, but that's essentially, you know, what a trust is. I gave something to a trustee with instructions that they use it for the benefit of somebody else. And she'd come back, and I give her another slice, and I'd say, okay, go give this one to grandma, give this one to Priya. Now, if she ate any of the pie on her way out of the kitchen into the living room, that would be a breach of trust, and, you know, she'd get in trouble. She'd be removed as trustee, off of pie duty, or you'd have to figure something else out. But that's an example of what a trust is. I mentioned earlier there were basically two broad types of trust: a revocable trust and an irrevocable trust. So a revocable trust is a trust that you can take back. You retain complete control over the property that's in that trust. You can change it at any time. So when we're talking about, I'll refer back to this pie example often. So hopefully none of you are hungry, because we're going to be talking a lot of pie. So when I gave that pie to my niece, I could have said, wait, nope, come back, give me that piece of pie back, and ate the pie myself. That I would have been revoking that trust. Or I could say, actually, you know what, don't give that piece to grandpa, give that piece to Priya. That would be, you know, changing the trust, and I can do that if it's a revocable trust. And when you have a revocable trust, your will becomes your plan B. Your goal is to get everything to pass through your trust, or to be owned by your trust before you pass away, because it's possible to avoid probate entirely. If you have assets, if you don't have any assets that are in your own name with no direction when you pass away, then we don't need to go to probate. We don't even need to get the will involved. So with a trust, your will becomes your plan B. You transfer your bank account to the trust during your lifetime. You name your trust as a beneficiary on your life insurance or retirement account, possibly. And we can just forego probate altogether, which can save quite a bit of money. The trust has some important things. It says who gets what and when do they get it, and it appoints a trustee who's in charge of the whole trust. So it can, like I said earlier, it can own the assets before you die. You can open up a new bank account in the name of the trust, transfer your cash to the trust, and now when you pass away, we don't have to worry about probate for that bank account because the trust already owns it. And this is a pretty common classic tool for estate tax planning and avoiding probate. Because you can revoke the trust, because you can change it, because you can take it back anytime, there's no protection from taxes or creditors. This has nothing to do with shielding your assets from getting sued, or avoiding or minimizing taxes in any way. It will help reduce estate taxes when you pass away if it's that kind of trust, but during your lifetime it doesn't offer any tax benefits. Now, an irrevocable trust is a little different. This cannot be changed once it's created. Once I give that pie to my niece and I say, give that to grandpa, that pie is going to grandpa. I can't get it back. I can't switch slices. It's going to grandpa. And so I can't get that pie back out. Now, an irrevocable trust is used for advanced estate tax planning. This is where, or mass health eligibility planning, or maybe you want to give away a gift. You want to get an asset out of your own name for tax reasons. But you want to set up some rules about how that person can use it. Maybe you want to give $10,000 to a family member to use for their education. Well, you can write them a check for $10,000, but if then they go and blow it on a new car or at the casino, they're out of luck. But if you give them, put it in a trust, you can set up rules on how they use it, and you can say, I'm using it for education. So that's just an example. Not the most practical way to pay for someone's education, but just by way of example. And with an irrevocable trust, you can set this up so that the person who created the trust pays income tax on it themselves. And the reason that you want to do that is because trusts get taxed at higher tax rates than individuals do. On the federal income tax level, the trusts get taxed at the maximum rate as soon as they make $12,500 worth of income, which isn't, in all likelihood, your rate, your individual rate is going to be lower than that trust rate. So typically with an irrevocable trust, we're not using it to avoid income taxes or anything like that. We're going to want to set up an irrevocable trust so that you're still on the hook for the income taxes because you'll be paying at a much lower rate. Now, I've talked a little bit about estate and gift tax. And if we're talking about federal estate and gift tax, it's basically the same thing. It's a tax on all of the assets you give away during your life or you possess at death. So if you gave away, $100,000 during your lifetime, then obviously we're talking about gift tax. If you give away $100,000 when you pass away as part of your estate plan, we're talking about estate tax. But federally, it's all the same thing. If you give away $100,000 during your lifetime and $200,000 when you die, you sort of just do all the math when you pass away and you say you've given away, $300,000. And it applies to all of the assets you're giving away either during your life or when you pass away. So this would include bank accounts, retirement accounts, real estate, life insurance benefits are included in the estate tax calculation, personal property, and of course business interests. So you basically add up all the value of all of these together, everything you own, everything you've given away during your lifetime, and then you apply a formula that the IRS sets out that determines how much tax you're going to have to pay. And that's how the federal estate tax and gift tax works. And Massachusetts does not have a gift tax. So you don't have to worry about filing a Massachusetts gift tax return if you're making gifts over $15,000, which is when you have to file a federal gift tax return. But they will add everything you gave away during your lifetime to your estate at the end when you pass away. So they're not taxing it when you make the gift, but they'll tax it when you eventually pass away. Now, the federal government doesn't care about estate tax as long as you have less than 11.48 million, which is quite a bit of money. So if you have less than that, you don't even have to worry about filing an estate tax return. And you only have to file a gift tax return if you're giving away $15,000 or more to any one person in a particular year, which means that if you give away as much as you want without having to pay gift tax, provided no one person is receiving more than $15,000 of either cash or stuff, whether it's a business, a car, a house, whatever it is. And if you do give away more than $15,000 to that one person, you're going to have to file a gift tax return, but we're not going to have to pay any gift tax. And that's because that 11.48 million that I was talking about, if you give away $30,000, and we've take away the $15,000, that's free to that one person. And then we've got this other $15,000 that we've given away. Well, we just take that off the 11.48 million. And now when you pass away, you can only give away $11.33 million. So, or no, even more than that. But you can, you're not going to have to pay gift tax unless you've given away more than that exemption. Now that exemption is so high, that federal estate tax exemption is so high, that's part of Trump's tax plan. Before that plan raised it up to 11 million, it was 5 million, and that got there during the Bush's tax plan. Before that, it was $1 million. So we'll see what happens, whether that number is going to change, whether it's going to go down, depending on who wins the election. So don't hang your hat on 11.48 million for the rest of your life. It may change soon. Now Massachusetts estate tax is 1 million. So if you have more than $1 million when you die, including the stuff you've had to file a federal gift tax return for during your lifetime, you add that all up, then and it's over $1 million, then you're going to have to file a Massachusetts estate tax return and may owe Massachusetts estate tax. And as far as the Massachusetts estate tax rate, it's a sliding scale, but basically think of it as 10%, basically, sort of the average percentage. So it might be more or less, but you add everything you own, add it all up, take 10% of that, and that's approximately what you're going to owe in Massachusetts estate tax, as long as that sum is more than $1 million. If you have less than $1 million when you pass away, and we're not going to be worried about a Massachusetts estate tax. Okay. So how does this all fit in with your business? Well, business is a thing you own and it has some value. So it's going to be included in this estate tax calculation. Or if you're giving it away during your lifetime, it's going to be included in that gift tax calculation when we're just determining how much money you're giving somebody if you're giving them your business. And just like your car, just like your coin collection or your baseball card collection, it's your bank account. It has to go somewhere when you die. Someone's going to need need to receive it, and it's going to pass according to your estate plan, whether you have one or not. According to your will, it will pass according to your trust, and that's why we care about your business when it comes to your estate planning. In the lifetime of the business, one of these 5 key events will occur. You as a business owner may pass away. You may decide to gift or sell your business to a family member. You may decide to sell your business interest to your business partner or another shareholder. You may sell it to a non-family member, like an employee that wants to take over the business. Or you may decide to wrap up the business, sell off what assets the business has, and liquidate. One of those 5 things will happen. And how we deal with those 5 things is how we're going to be looking at now, and how that works with your estate plan. Let's say you own your business and you pass away. So your will or your trust, which can help us avoid probate, is going to be decided. It's going to dispose of the property, including your business interests. So what we can do, one of the things we're concerned about is maybe you actually have 2 children. One of your children loves your pie business. They love making pies as much as you love making pies. Your other child is gluten sensitive, hates pies, is not interested in eating pies, doesn't want to see another pie. She's had enough of you and your pies, so is not interested in owning the business. Well, let's say your pie business is worth $200,000, and everything else you own is worth $100,000. Well, one of your children really wants the pie business, so if we give her 100% of the pie business, she's got $200,000. Well, what's left for your other child? Only $100,000. So, now one's getting 200, one's getting 100. Yeah, she doesn't have to see another pie for the rest of her life, but nevertheless, that's not equal. So using a trust, we're going to look at ways we can equalize value. Maybe you set up 50% of the business for your daughter who hates pies and a trust. She doesn't have to be part of the trust. You can just get the income from the pie business. She doesn't have to help run it. That doesn't necessarily sound very fair to your daughter who loves pies. She was doing a lot of the work, 100% of the work, but only getting 50% interest in the business. Well, maybe life insurance can be an asset that we can purchase life insurance for $100,000 in order to equalize that. So your daughter who hates pies gets $100,000 of property, $100,000 of life insurance, and your pie-loving daughter gets the $200,000 pie business, and now everyone's got $200,000 and everyone's happy. Using so you can allocate the business through your trust or your will, and we can use that to minimize estate taxes as well. And this may be by passing the business to your spouse or setting up a particular type of trust that's going to reduce estate taxes when you pass away, as well as when your spouse passes away. As I referenced earlier, we can create trusts for people who are not able or not willing to manage the property the trust is receiving. They may not be interested in running a pie business, but it can also protect their interest. If a trust receives the business interest, it can protect your children's interest, for example, from what I call the GDDs. And the D's is the list of things such as death, divorce, destructive spending. These are bad things that can happen that could happen to your children and eats into the assets that you've passed on to them as part of your estate plan. So, for example, if the business that you pass on to them is held in a trust for their benefit, It's a trust that you set up before you passed away, and now it owns the business, and your children manage it. Should their spouse decide to divorce them because they're tired of hearing about pies day in and day out, then that spouse isn't able to go after that pie business. That's protected in a trust. It's not even part of the calculation when deciding who gets what asset as part of that divorce, and that ensures your business is going to stay in the family, which can be very important. And of course, with a trust, you can set conditions on the gifts. So maybe you give some of your children the right to purchase part of the business should they want it. You know, maybe the child who hates pies is going to come around by the end and may want in, so you can set up options like that, where if you want to be part of the business, you can take part of the business. And you can lay out rules about what that means to be part of the business. You have to actively participate in the business, for example. So really, just the point I'm trying to get across there is setting up a trust that deals with your business in a thoughtful way can really be a powerful tool, and almost only limited by your creativity about how you want to go about passing on your business to your children. Now, let's say we want to give away the business or sell it to family members. You can give your business to your next generation today rather than waiting for you to pass away. And there's a few ways you can go about doing this. You can just give them the business interest outright. It's not in a trust, you're just giving it to them, or you can do it in a trust. Like I talked about earlier, that can be a great way to protect those business interests from those GDDs, the divorce, their destructive spending habits. Maybe, they accidentally hit somebody with their car and they're getting sued. Well, their interest in the business isn't going to be something they can go after if it's protected in a trust. Or maybe your children are going to set up their own company and receive the business and the assets and the contracts in that new entity. So if you wanted to, you can gift and sell the interest to a trust rather than to the children outright, and that's going to, like I said, give the protection from those GD. You can think about how you're going to gift it to them. Let's say your business is to use easy math. Let's say your business is worth $30,000 and you want to give your business to one of your children. Well, this year you can give them $15,000 worth of the business, so you can give them 50% of the business this year. You can give them 50% of the business next year, and now we're not worried about having to ever file a gift tax return. Or another option is to sell your interest to your children in a way that retains some income stream. So they may not have the cash come up and buy your business outright for whatever it's worth, but that could be okay. You can sell your business to them and get back what's called a promissory note, which basically means it's basically a loan. They would pay you a monthly payment for a number of years or for the rest of your life until they've paid off the value of the business. And that way you can step out of the business, you can take a backseat role in the business maybe, but you're still retaining income from your business, which can be a great way. Everyone would love to have some money when they retire, and that's a way to do it. You can sell it to an intentionally defective grantor trust, and that's a type of irrevocable trust that can own a business. And the reason that we do that is you can reduce the value of your business when you make the gift. Let's say in reality, if you were to sell your business on the open market, your business would be worth $100,000. Well, we can structure this trust so that instead of being $100,000, the way we structured everything, the value that the children are receiving is, on the open market, it's $100,000. But through all these, different terms you put in the trust, they're only technically receiving $70,000. Well, that means you've got more to give away during your lifetime. Rather than use $100,000 of your federal estate and gift tax exemption, we've only used $70,000. However, your children they've received something that is worth $100,000. You and I know that, but as far as the IRS is concerned, they're only receiving something that's worth $70,000. I'm not going to really go into the bullet points on this. It can get pretty complicated, and the bullet points don't even fully explain it. But that's one strategy to gift your business to the next generation. Another couple key points about that is, you do receive income stream. it's reducing your estate. It's getting it out of your estate so that when you pass away, it's not added to that $1 million that we're concerned about for Massachusetts estate tax. And you get to retain operational control. You get to still be part of the business. You're there for your children to consult with you if they have questions about the business or need your help on something. And you can control which of your children who gets it and who gets a stake in the business. So that's just one type of trust you can use to gift a business or sell a business to your children during your lifetime. Now you may want to transfer your business to a shareholder, your business partner, or another key employee. So your family is not interested in being part of your pie business. Your spouse isn't, your children aren't, but your business partner obviously loves pies almost as much as you do, and so they'd love to have your half of the pie business and keep it going when you pass away. And the way we do that is with what's called a buy-sell agreement. And I'll get into a little more detail on that, but it's basically if these key events happen, if you die, if you want to sell your business, the rules of this buy-sell agreement are basically saying, I have to sell it to you and you have to buy it to me. And one of the ways that we can guarantee that happens is by owning life insurance on your business partner. And they own life insurance on you, so that if they pass away, you get this life insurance payout, which allows you to go ahead and purchase their half of their business from their estate. You now own all of the business, and you don't have to run this pie shop with your business partner's spouse, who you never really liked anyway. This offers protection from creditors and ex-spouses, from taking a claim of the business if something happens to your business partner. It can be used to reduce estate taxes, including saving some income taxes, such as capital gains, which is outside the scope of this conversation, but know that it can help save some income taxes there. And you can also throw in some non-compete agreements and some non-disclosure agreements. So, if your business partner wants to leave the business, you get to buy out their 50%, but they also can't go ahead and open a pie shop just down the road and try and run you out of business. Not only that, they wouldn't be able to go tell everyone the secret ingredient to your pies and sell that on the open market. So a buy-sell agreement can be a powerful document. And essentially, there's three types of buy-sell agreements. The most common is this cross-purchase agreement. If a particular event happens, one owner is obligated to sell, and the other owner is obligated to buy that other owner's business interest. There's also a redemption agreement where the company is buying out one of the business partners, and there's also something that's called wait and see, which is a combination of the two options. Either the company's going to buy or the other business owner is going to buy. The most common and the one I'll be talking about for most of the rest of the presentation is that cross-purchase agreement, where you're in business with you and a business partner. Could be more than one business partner, but I'll mostly be talking about two people in business together buying each other's out. So we'll be talking about these triggering events. So what might be an event that'll occur that'll trigger a buy-sell, where you have to buy your business partner's interests, or they have to buy your business partner's interests? Well, one of the more common ones is should either of you pass away. You might not want to be in business with your business partner's spouse. So should they pass away, rather than their spouse receiving their half of the business, again, you can say, you can buy that out from the estate, and they have to sell it to you. And now you own 100% of your business, and you don't have to be in business with your partner's spouse. Maybe one of you becomes disabled, and this would be a good time to have disability insurance, because if you have disability insurance, when you becomes disabled, they can't make the pies anymore, then you can buy them out. They get the cash for their 50% of the business, but now you own the whole business and can run it because they weren't able to anymore. Should one of you want to retire, then they have to sell their shares to you, or again, vice versa, so that it stays within the people who care most about this business. One of your divorces could be a triggering event as part of a buy-sell agreement, such that if your business partner's going through a divorce, then you have to buy out their 50% and they have to sell it to you, which means that you now own 100% of the business. Your business partner owns 0% of the business. So that when the judge is dividing up assets as part of their divorce, the business doesn't enter into it. So you won't end up, in business with, with your business partner and their ex-spouse. So that's another great tool that we can use the buy-sell agreement for. Another triggering event is maybe they want to sell their business. They want out. Well, they can't just sell it to anybody. They can't pick your new business partner. We write it in that you have to buy out their share and they have to buy out your share if either of you want to get out for whatever reason. Maybe they don't want to sell, but they're going to have to. Maybe they're going through a bankruptcy or there's another court order ordering them to sell their half of the business. Again, with a buy-sell agreement in place, you have to buy out their half. They have to buy out your half, and that way you stay in business with the people you're interested in being in business with, and not whoever randomly buys their half of the business. And maybe they've lost their license. Maybe you're dentists, and you each own half of a dental practice, and one of you loses your medical license. Well, then you can buy them out, and they have to sell the shares. And the key thing to any buy-sell agreement is the value that we're placing on the business. So if, let's say, your business partner is going through a divorce, the buy-sell agreement will say, if one of the business partners is going through a divorce, the value of the business shall be 0, which means that they have to transfer their 50% to you, but the amount that you have to pay for it is $0. And the reason that we want to do that is because, if the business was worth $100,000 and you had to give them $50,000 for their share in the business, well, now they have $50,000. It's going to get divided up in the divorce proceedings. So we want to minimize the amount of money that they have for their sake. Once the dust is settled on that divorce, you can give them their 50% back, and they can get back into business with you. So that can be a tricky way to discourage people either from going after the business during a divorce or even upon a family challenge. Let's say you left your business to your daughter who loves pies, and you didn't leave your business to your daughter who hated pies. That made good sense at the time, but turns out your daughter who hated pies now suddenly wants in. She's saying, that's not fair, I want part of the business. Well, if you have the buy-sell agreement in place with your business partner, if your family is challenging your estate plan or challenging this buy-sell agreement, it'll reduce the price of your business to 0, which means that you don't have to. The people who are buying it don't have to pay anything for it, which consolidates it into the one business partner to avoid your business partner's family challenging and fighting over that business. The buy-sell agreement itself, as I was saying earlier, will set the value of the business, and you should look at that value annually. So maybe the first time you sign the buy-sell agreement, the business is worth $100,000. So you each take $100,000 worth of life insurance or disability insurance out on the other one, because that would allow you to. I'm sorry, your business is worth $100,000. So you take a $50,000 life insurance policy out on each other. But the next year, maybe business was great, and now your business is worth $200,000. Well, you should look at that again and maybe purchase additional life insurance. And it should also have a mechanism in there to determine the value. Should the two of you not go back and determine the value for the purposes of this buy-sell agreement every year? Because let's face it, we're only human. This is probably going to be something we forget to do or we neglect to do. I've seen it a lot. So you want to have some rules in there about how, should you not set the value each year, how we determine what that value is. And two ways to do that would be a objective valuation. So there's companies whose job it is to go out there and look at the business. What does it own? What assets does it have? What sort of income was it making? As well as what money does it owe? And they come up with a value for the business. Or you can just use what's called book value or adjusted book value, where you're just looking at sort of what the business has. What would it be? What could you sell its stuff for? To determine the value of the business. So you want to set one of those up in a good buy-sell agreement. And of course, how do we pay for it? I've been talking about you buying their half them buying your half. Of course, like I said, you can use life insurance so that if your business partner passes away, you get the money, you get the cash, and now you can buy their share of the business with the cash. Of course, that only works if your business partner passes away. If they become disabled, then having disability insurance on each other can be valuable as well. Or you can set it up so that the purchase is made by a promissory note, where you're paying a particular amount to their estate or to them over a period of years until you've paid off the full value of their half of the business. So you don't have to come up with the cash all at once. There are some, like I said, benefits of using life insurance or disability insurance. You get all the cash at once right when you need it. These proceeds, the life insurance proceeds, are tax-free. So we're not worried about income tax with life insurance proceeds. It reduces your family's reliance on the business cash flow to purchase the interest. Once you purchase that, your business is worth $100,000, you purchase that $50,000 life insurance on each other. You're less worried about the business cash flow providing that money to buy out your business partner should something happen to them. Remember, you have to buy them out. So if you're less concerned about the cash flow once you get that life insurance in place. And of course, the buy-sell agreement, it prevents your business partner from having to go into business with your family and vice versa. You chose to be in business with your partner, so having these buy-sell agreements in place is a way to ensure that you stay in business with your partner. A buy-sell agreement, you don't have to have them with your business partner. You can have them with a key employee. They are agreeing to buy the business from you or your estate should something happen to you. But if you are self-employed, some of the key things to think about are having disability insurance in place. If you suddenly become disabled, unable to manage the business, we want to have some disability insurance that'll keep the business either afloat or help with those expenses. Long-term care insurance can also be something that purchased at a young age. Start thinking about it around age 55. Can help defray any long-term care costs, and so we don't have to tap into the value of the business to pay for your long-term care as you age. If you do have employees, one thing to consider to keep and attract them to maintain the value of your business would be something like a small group benefits plan or employee ownership or retirement plans. But regardless, any of these transitions, especially if you're selling it to a non-family member or you're self-employed, if your exit plan won't succeed without competent management. You need the good employees there to take over your business to run it if it's not going to a family member. So just to end here, we talked about a lot. I don't think you saw any questions come up as we were going through. We covered a lot of ground, but one of the key takeaways, and this is what you should really do before you go talk to any attorney or as you're thinking about your business plan, ask yourself some tough questions. Does your spouse or your children want to be involved? Maybe they want to be involved, but they haven't really demonstrated that interest. And so they're not part of the business really. So maybe it wouldn't be a good idea for your children to receive your business even if they want it. You also got to think about how you treat your children fairly if only one of them is going to be receiving the business. If you have enough assets, is there a way to equalize the value that each of your children may be receiving? You want to think about how stable your children's families. And maybe your children's spouse, you don't think much of them and you think that at some point there may be divorce in there. Well, it's a good time to set up the kind of trust that's going to protect your business from that divorce. And then would you want your business partner's spouse to be in business with you? Think about those and whether or not you want to get a buy-sell in place. Or if it's, a big family business, everyone's working in the business, then, of course, that's great too. That could simplify things, but you want to plan for conflict should it arise. And is the plan that you're putting in place, or maybe a lack of a plan now, is it going to be creating conflicts in your family? So those are some of the key things to think about as you start mulling over your estate plan, as well as the estate plan in particular regard to your business. So let me know if anyone has any questions. I'm going to figure out how to stop sharing my screen. There we go.
Thank you, Will,
Of course.
for presentation. We have attendees. If you just want to unmute yourself, if you are muted, and if you want to share comments or questions, we want to open it up to give you that opportunity to ask some questions to Will, or just provide some feedback. I know there's another, we are planning another session coming up, hopefully by next week, where we're gonna be talking about commercial leases as well. So that's gonna be kind of like a continuation to the series, and Priya is gonna be presenting around that. So are there any other information, maybe Priya or Will, if you want to share any other comments? I want to be able to provide with the space to do that.
Yeah, I'll give everyone my email address. And if anyone has any questions they want to ask or anything else, they can just email me.
And what we can do too is in the thank you email, we'll send that information as well.
Okay, great.
This is Aneda. I just want to add, first of all, Willie, this is excellent. Thank you so much for sharing all this valuable information. You know, I also do estate planning, and a question I get a lot, and I'd love for you to share a little bit more about your thoughts about this, is, you know, when people create, even if it's an irrevocable trust, they're worried about control, right? They're worried about, you know, well, if I put my assets in a trust, how can I make sure that I still have access to it? Can you elaborate a little bit about, you know, how, even though, you know, you're the grantor and you know, you have a trustee, like how can you still make sure that during your lifetime in an irrevocable trust, you keep certain control of the assets?
Yeah, I mean, that can be, you know, that can be a tough one. Often I'm telling people, you know, just, you know, you got to think carefully about who you're choosing as a trustee. You know, you could certainly put provisions in there about, you know, who can be a trustee should your initial choice stop being a trustee, obviously, or need to be removed for whatever reason. You know, you can set up an irrevocable trust certainly to still receive the income that trust is generating, whether, you know, if that owns your business, it can generate the income. But, you know, that lack of control is something to balance with, you know, with the potential savings from setting up an irrevocable trust like that. You know, that can be, you know, you are giving up a level of control, which is why the government is giving you these tax benefits, is because it's something that you are giving up. So you just really have to, you know, choose your trustees wisely and set up terms that, you know, that you're happy with, that you're confident that A, they can stick to, and B, will protect the thing that you care about, which is, you know, your business and your family. But that can be, you know, that's, you know, picking that person and having the faith that they'll have, you know, act with your best interests, with the instructions you've given them in the trust can be, you know, can be challenging sometimes.
Thank you.
Thank you, Aneda, for your question. Anyone else? Any other questions? Well, I guess we cover everything, and I really appreciate all of you joining this afternoon. That was a great presentation, a lot of great information. So we thank you very much for providing that for our business community. As I mentioned earlier, this session was recorded, and we want to make sure that it's available for those ones that I knew were interested in this topic and couldn't join today. So we'll share that in our thank you email, and we'll continue building this virtual series with all of you and all of your feedback. I hope you are having a wonderful day, that you're going to have a wonderful rest of your afternoon and evening. Stay healthy, stay safe, and thank you for all you do. And just stay in touch with Amplify. There's much more information that is coming up, and many other webinars that we're going to be presenting through the series. So thank you to our speakers, and have a wonderful evening. Take care.